The final medical document that we're going to provide is commonly referred to as a living will. It does go by some other names, including Advance Medical Directive, and some jurisdictions also call it Instructions for Medical and Surgical Treatment. They all fall under the same umbrella of a living will. Now, for purposes of a living will, there are a couple clarifications I like to provide before we actually look at the document. Number one, very importantly, a living will is designed to address decisions and processes regarding what we would commonly refer to as life support. It does not, number one, act as a DNR. A do not resuscitate is another form of advanced medical directive that people oftentimes at advanced ages or advanced illnesses, they'll actually end up having both. The living will to address life support and the DNR to address certain specific medical procedures that we want to control either happening or not happening. As an example, in a DNR, you're typically going to say, I don't want CPR if something happens to me. I don't want to be intubated, which is a highly invasive form of medical intervention. So if you get to a point that you want to look at having a DNR, the document in Colorado that we use is actually called MOST, M-O-S-T. It stands for Medical Orders for Scope of Treatment. To the extent at any point you have an interest in discussing those topics, it is the one document as part of your planning as a whole that an attorney cannot prepare for you. A DNR, a MOST form, is required legally to be signed with a physician because they have to consult you about all of the different implications of your choices. So I'm always happy if you ask to provide you a copy of that MOST form so you can see what it looks like. And then you want to take that to a physician so that you can actually discuss, fill it out, and sign it. The last clarification that I like to provide, living wills, they address removing us from life support once we have been placed on it. This document does not prevent us from being put on life support in the first place. It's an important understanding. It only activates once we are on life support as a means to then provide when to take us off of life support. So the document way right is fairly short and simple, but it's really important to read it and understand it. So first, the clarification to provide, we use the terms life support a lot when we talk about our end of life decisions. In the legal context, we're going to call these life prolonging procedures because life support mostly refers to the machines that are actually turned on and keeping us alive, like pumping our lungs, for example. But when we pass away, it's important that we understand the process for not only turning off machines, but also stopping any artificial nutrition like a food pump, stopping any hydration measures. We need to ensure that everything that we have happening turns off at the exact same time. What most people don't understand about the dying, the transitioning process, the very first system that tends to shut down for us is actually our digestive system. So if I turn off the machines that are keeping me breathing and all of that, but I don't stop the food that might be being pumped in or the water that I'm receiving, that's going to cause a lot of problems. First is it's going to continue extending my life much further than I want it to be extended. And without those machines turned on, it's going to be a lot more unpleasant. And then the second primary issue is if food is being introduced into my body, but I don't have a digestive system to digest it, then that food is going to essentially start poisoning me. So it's critically important that we turn off all systems at the same time. Your living will, it's a document that's going to be activated once it's determined that you're actually at the end of your life. And the two circumstances that we have right now for that are number one, the vegetative state, the permanent or the persistent vegetative state. This is saying that my body may be perfectly fine, but I no longer have any higher cognitive functions, and I'm never going to again. And the second issue is it goes by some different names, but it's a situation where there is simply nothing that can be done to keep me alive. We commonly call this being in a terminal or an incurable condition. So, as an example, there's simply no more medical procedures. There isn't a surgery that can be done. There are no medications that I can take. There's no technology we can use, except for the fact that that life support effectively is still turned on. I have passed away. So in your document, very simply, at the beginning, it's providing, if it is determined that I am in one of these conditions, I do not want to be on life support. I want you to end it once all of these once all of these legal matters are resolved. Statement of intent, honestly, very simply, this is my decision. I'm making this because I don't want to be miserable in very short terms. So the statement of intent, you are more than welcome to supplement this if you'd like to say anything else. But it effectively is saying, this is my decision. Don't feel guilty about it. And then authorization of the surrogate. Remember that we're going to have people serving for us, such as a power of attorney. This is making sure that they have the power then to facilitate my living will, to turn everything off for me. And release of liability, the person who's doing that for me, they can't ever get in trouble for doing that. If my sister ends up deciding that it's time and we turn off life support, my other family members can't go and sue her and say that she made the wrong decision. When this happens, we want to make sure that people are protected from any, bad faith, any people who might just be very upset by it. Now, in the context of a living will, a little bit of background. Every state has different rules and processes for going through this. Every state has their own law. It's one of my frustrations in this particular realm of legal work, because I wish that there was consistency, that there was one law for the entire country, but there isn't. I can tell you how it works for Colorado, and I can tell you that there is consistency for the most part, state to state. So when we get to a point that somebody believes we have reached the end of our life, step one, very simply, is we need to prove that. We're going to bring in a physician. We're going to bring in somebody who is actually qualified and experienced to being able to determine this. And so that physician is going to come in, and whatever medical regulations tell them to do, that's what they're going to do. So running labs and tests, looking at my medical record, evaluating me physically. If a physician comes in and says yes, let's say vegetative state, in Colorado and in a lot of states, we now have to bring in a second doctor. That second doctor, we have to determine if the first doctor got it right. So they're going to do the same things. If these doctors come in and they agree, I've gotten to this point, once that determination is made, then there's going to be a waiting period. 2 days, 48 hours. Is anything going to change for me? Technically, it's also a point where people can object and say, I disagree with what the doctor said. That's very rare, but it can happen. After 2 doctors do all of their work and these 2 days pass, if nothing has changed for me at that point legally, I can be removed from life support. And so this document here is saying, please do that. Now, there's a couple ways that people might modify their living will. Number one, the document is acting on my behalf to make these decisions. Sometimes people are not comfortable with that. Sometimes, whether it's personal reasons or religious reasons, clients might say, I need my spouse to be the one who makes that call. I need the kids to be the one who makes that call. We can do that. If it comes to that point that you are not comfortable with a living will and doctors essentially being involved to decide that process, we can restructure this in a way that the person who's serving for you can make it. The one drawback, the one warning that I'll give you about that is, at a time when people are highly emotional and they're already grieving, asking them to take on the responsibility of deciding when you live and die, It's a lot, and it's not something I would typically recommend. The second thing we might do here, some people will say, I don't want to be on life support, but I do want to make sure that there's a minimum amount of time that I am. Sometimes this is because we may have family that are in another state, and we want to make sure that there's enough time for them to get here. Other reasons, it might just make me feel more comfortable. So I can specify a minimum amount of time in here, maybe 3 days, maybe 5 days, maybe 7 days. A handful of days is not the end of the world. And if it will make you more comfortable, let's do it. We don't want to get to the point, though, where we're saying, I want to be on life support for 30 days because the time, the cost, and frankly, the misery that you might be in for that, it's not worth it. Finally, the last thing we might do here, kind of harkening back to the discussions about the medical power of attorney, is we might instill any additional guidelines or preferences into this document. As an example, my Catholic clients that I have mentioned, they may want to have their last rites performed before the living will is activated, and we can achieve that. Some people, it may just be simply saying things like, here's where I would want to be. Maybe I want to be at home when I die. Maybe I want to be in a facility or a hospice or something like that. Others may just say things like, these are the people that I would prefer to be with me, or this is an object that's really important that I want to have with me. One of the movements that's happening right now that I wholeheartedly support is we're being more conscientious about how we die. And so, to the extent you may have any preferences or wishes, tell me, because we can again put those in this document, or maybe we itemize them in a separate set of guidelines that we provide as part of your estate planning. Now, with the living will, again, it's a very short and simple read, but as you may have those questions, those additional thoughts, we want you to tell us, and then that will complete your review of all of the medical documents.